Good evening, friends. Welcome to the YouTube channel Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which I am going to discuss today is Principal Commissioner of Income Tax versus SWATI BAJAJ. This case has been reported in 446 ITR at page number 56 and the matter has been decided by Calcutta High Court, and this case has been decided on 14th June 2022. Friends, this case is very harsh on the Assessee. It disposes of 90 cases in one go. This case is related to the penny stocks in which the ITAT has given relief to the Assessee, but all the cases has been disposed of in one appeal by the Calcutta High Court. Friends, in past we have seen that the courts are very harsh on the Assessee, even the legislature, and it seems that now our courts are also expecting from the Assessee that they should do the impossible, with due respect to all the high courts and the Supreme Court. This is the perfect example that such a harsh decision is there, and I do not know that what effect this decision will leave on the Assessee. There is no much in the merits of the case, because in this case there was penny stock matter which was decided in favor of the Assessee, because the Assessee was saying that the investigation report was not given to the Assessee, the cross-examination was not provided to the Assessee. The Assessee do not have any role why the prices of the shares are increasing, so you cannot blame the Assessee. The Assessee was taking the plea that the Assessee is a regular share trader. He is also dealing in a number of other blue chip companies also, so he was a regular share trading person, and if in one share or the two share he gets some abnormal gains, that it should not be seen with the colored glasses. But the High Court came very heavily on all this, you can say, whatever the Assessee takes the plea, and turned down all the pleas taken by the Assessees and various professionals which are representing the Assessee. The first thing which the court said in this particular case, the breach of the audi alteram partem rule cannot by itself without more lead to the conclusion that prejudice is thereby caused. Friends, we see that we take this plea that proper opportunity of being heard has not been given to the Assessee. Proper opportunity of being heard means that I was not listened properly. It means that personal hearing was not given to me. It means that I was not given the sufficient time to explain my matter. Whatever the statements the department is relying, those persons were not made available to me for cross-examination. Court said that in this particular case that even if the audi alteram partem, that is the opportunity of being heard, is not given, then it will not itself mean that some prejudice is there to the Assessee. I am very surprised that how this particular statement given by the court in this particular case will affect the Assessee. Court is saying that if the principle of being heard to the Assessee is not given, then there are chances that the Assessee is not prejudiced. So it means that in every case we cannot take the plea that I was not being heard. Even if I am wrong, even then I should be given the opportunity of being heard with due respect to the Calcutta High Court. The second point which the court said that the right of hearing cannot include the right of cross-examination. In all these cases where the department relies on the statement of some entry operators or some other persons, then we have the right to say that please give us the opportunity of cross-examining the person who is giving the statement against me. But in this particular case, the court said that hearing cannot include the right of cross-examination. This is very surprised that how the officers will take this case. Now, if this judgment will be followed, then the right of cross-examination is gone or will be slipped from the hands of the assessee. The next thing, the court said that the assessee cannot be allowed to contend that the language employed in the orders passed by the commissioner under section 263 does not mention about how the assessment order was erroneous insofar as it is prejudicial to the interest to the revenue. Friends, as we all know that the commissioner has the power under section 263 to revise the order if it is erroneous and prejudicial to the interest of the revenue. The court said in this particular case that there is no need for the CIT even to mention into the order under section 263 that how it is erroneous, how the order of the AO was erroneous or prejudicial to the interest of the revenue. Friends, it is totally out of my thinking that without CIT mentioning in the order how the order of the assessing officer was erroneous or prejudicial to the interest to the revenue, how the assessee will defend his case. If I will not be able to know that earlier the assessment order passed by the assessing officer was erroneous in what ways, then how the assessee will fight his case. But very surprisingly, the court said that the CIT appeal is not bound to mention in the assessment order that how the order of the AO was erroneous or prejudicial to the interest to the revenue. The next thing, the court said that because in this particular case there were 90 cases and in most of the cases the chartered accountants and the advocates were asking the investigation report on which the department was relying or the assessing officer was relying and which was not provided to the assessee. So on this particular matter, the court said that this report was available on the internet. Even if the department has not given you the report, then you must have taken that report from the Google and you have countered your reply according to that. Friends, how I can take the report from the Google? Suppose if I have taken the report from the Google and the contents of that report is not the same with the contents of the report which is available with the AO. So how I can defend myself with a report which is taken from the from any website or from Google? It should come through a proper channel. But the Honorable High Court said that you should make your efforts to download it from the internet. The next thing the court said that it is the duty of the assessee to explain the justification for the steep rise in the prices of the shares. Because generally we take the plea that if I am purchasing my any share and if the price of the share increases, then before selling the share into the market, now I have to gather the information why this share is increasing. It is beyond my control because there are thousands of the reasons through which the share can increase. How the assessee will come to know the affairs of the company, that why this price is fluctuating? There may be international reasons, there may be some, there are very big players in the market due to the prices fall and prices rise. Now if the assessee is claiming the loss, you have to explain the decline in the price. And if you are claiming any exempt income or you are taking the benefit of the increase in the prices, then you have to explain the steep rise in the price. Friends, according to me, as a student of law, I am failed to understand how the assessee will be able to explain the steep rise or steep decline in the prices. But the Honorable Court has casted this duty on the assessee. Next point on which the court said that the assessee takes the plea that assessee is dealing in the number of shares. The assessee is also dealing in the shares of other blue chip companies also. So by saying so, the assessee is trying to say that I have not purchased this hanky panky shares. I am a regular trader. I am purchasing a number of the shares. So if one share I got the benefit, then it is my normal business profit or normal capital gain. But on this, court say that this is not a valid ground for the assessee. This is not a valid claim of the assessee that you are dealing in the other blue chip companies also. Friends, this is very surprisingly, because when an assessee deals only in one penny stock or two penny stocks, then the assessing officer says that the assessee is only dealing in one share. Now, the assessee is saying that, sir, I am also dealing in the number of shares, then you are not taking this plea also. So it means that now the policy of the assessee is being run to the end of the earth to explain its point. But this is very unfortunate on the part of the assessee that before dealing in shares, the assessee has to keep all these things in his mind. The last point which the court said that the tribunal, while disposing of the matter in the 90 cases, the tribunal has not examined the facts of most of the cases, and the order passed by the tribunal is perfunctory in nature. Friends, I am not worried about the fate of the 90 cases, but I am worried about the law laid down in this particular case, about the point of cross-examination, about the point of audi ad alteram pattern, about the duty casted on the assessee to explain the steep rise in the prices, and even the assessee cannot now ask for the cross-examination or the investigation report. So whatever the investigation department has said, it has become now a Bible or the Gita or some other holy book for the department, and the department can do anything with the assessee with the investigation report. Friends, these cases will be having a very far-reaching effect on the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus SWATI BAJAJ. Thank you, friends.